Welcome back to another episode of Law Scholars. In this episode, we're going to be talking about mistaken identification and the risks of mistaken identification, and then the exclusion of evidence that results from mistaken identification. So we have finished our discussions about Miranda and the right to counsel and the right, well, I'll take that back a bit. There is some right to counsel aspects of this that we're going to be talking about, but mistaken identification is kind of a separate subject. So let's start with the risks of mistaken identification. And specifically, we're going to be talking about eyewitness accounts and how unreliable eyewitnesses actually are. Let's just say they're not as reliable as you might think. The more complex the eyewitnesses are asked to recall, then the more unreliable that testimony is going to become, even though their certainty is going to be pretty high. So what might influence how an eyewitness encodes and recalls information that they actually report? Well, there are several factors. First is whether or not there are any bystanders, the angle that the eyewitness had towards actually viewing the face of the perpetrator, how often eyewitnesses are asked to recall information before they are actually visiting with the police, how many officers the eyewitness is going to be talking to, and there are just so many different factors as well that influence and alter and change whether or not the eyewitness is going to give or recall their memory properly. All this to say is that in simple situations, eyewitnesses are going to be accurate about 90% of the time. But when you complex that situation to the average situation, is going to be about 75% accuracy, and then even more complex situations, the accuracy of descriptions drop below 50%, which means that eyewitnesses are more than half the time in complex situations pointing to the wrong person, saying that person did it. And so you can see why eyewitness accounts lead to a pretty high number of wrongful convictions when it comes to comparing those to other identification methods such as DNA evidence or even circumstantial evidence. It is the case even if the witness feels the suspect is not present in a lineup, well then still 60% of people are going to identify somebody as the person who committed a crime. So let's talk about exclusion of identification evidence based on the right to counsel then. Well, we've got one case here we've got a couple of cases here, two cases. United States versus Wade. What's our rule here? Well, after the initiation of a criminal proceeding, which we talked about in a previous episode about the right to counsel, then the defendant has the right to counsel. And they have that right before any corporeal identification is made. If the identification is made in violation of this rule, well then a suppression of that identification and the in-court identification may be also excluded unless the state can show that an in-court identification is independent from the lineup procedure that ended up identifying the person in the first place. Why is this? Well, let's talk about some of our reasoning and analysis. Before the founding, the purpose of the Sixth Amendment was to allow defendants to be confronted with their accusers. In other words, defendants have the right and the opportunity to cross-examine their accuser. In this case, in United States versus Wade, there was a lineup that happened, and the lineup picked up the wrong person, or Wade's saying that the lineup picked up the wrong person, and the government is arguing that the lineup is simply procedural and doesn't require a attorney to be present at the lineup. They say it's procedural because it's fairly similar to the process of fingerprinting or conducting a record search, and there's no right to counsel in those situations. Here, however, in United States v. Wade, the court is going to disagree and say that the lineup is part of a critical stage of the investigatory process where a defendant is presented to the accuser without the ability to cross-examine that accuser's declaration. So the right to counsel needs to be there to protect the defendant from an uncontested accusation, and presenting this evidence at trial does nothing to relieve the burden on the defendant, where all that person can do is deny the accusation that was made without an attorney present. On the other hand, the concurring and dissenting opinions here argue that the majority's analysis goes too far and prohibits officers from creating lineups due to the difficulty of having counsel present for each individual that might potentially be involved in a lineup, because a lineup typically has 5 to 6 individuals, and if you're going to ask the police officers to find counsel for each one of those individuals to be present, well, then that might be a bit of a impractical reality. Okay, then we have People versus Hickman, and the rule here is that all pre-prosecutorial identifications are not a violation of the Sixth Amendment, meaning that the right to counsel has not attached yet. So if you haven't been in the prosecutorial process yet, you don't have that right to counsel. So after Wade was decided, the court handed down another case called People versus Anderson, which extended the right to counsel in any situation where the suspect is being identified, regardless of whether prosecution has begun. The rule was pretty confusing to the court and resulted in several cases trying to define how sufficient evidence was before that right actually applied. There was a case here, People versus Dixon, that said that it required a mere suspicion. And if there was a mere suspicion, well, then the right applied. And then you have People versus Turner, which says you needed a very strong showing of evidence in order for the right to apply. In other words, inconsistent standards arose because People versus Anderson happened here. And so the majority determines that overruling Anderson is the proper rule, and that any pre-prosecutorial identifications are not going to be a violation of the Sixth Amendment. The dissent does argue that overruling Anderson leaves the suspect with very little protection during the identification stage of the investigatory process. And essentially, as long as the suspect has not been charged or brought to a tribunal, then the suspect is going to be subject to the whims of the investigatory officer. It may just be influencing a witness to identify the suspect as a potential perpetrator. Due to this timing in the rule, most identifications are not going to be a violation of the right to counsel. Most identification procedures happen before somebody is within the realms of the prosecutory process. I do want to also mention that there is no right to counsel for a photo array or a right to counsel for show-ups. So you can see that we have different kinds of lineups and different times where at different times when the right to counsel might be required. So, what do you do? Well, that is the exclusion of identification evidence based on the right to counsel. What about the exclusion of identification evidence based on due process? Different, but related. We have here State versus Henderson, which outlines in both the federal rule and, in this case, the state rule for this particular state. The federal rule considers a test in Mason versus Braithwaite, which provides a 2-step analysis. It says, first, whether the procedure of identification is impermissibly suggestive, and second, whether the objection if the objectionable procedure resulted in a very substantial likelihood of irreparable misidentification. In other words, is the identification reliable? And if both those factors are going to be wrong, well, then you can say there was a violation of due process and that evidence might be excluded. For the second prong, the reliability prong, the court is going to look at 5 factors in nil versus Biggers. Those 5 factors are: what opportunity did the witness have to view the criminal at the time of the crime? How attentive was the witness at the time of the crime, which attention might be diverted by the presence of a weapon? Is the description of the criminal accurate as provided by the witness? How certain is the witness of the identification that they make? And then what is the gap between the crime and the identification procedure? How long between those two events occur? Now, the state test here says that this is going to be pretty not protective of subjects. And so the state wants to consider several systematic and estimator variables. Each one of these kind of adjusts and touches on those 2 prongs in Mason versus Braithwaite. The first is going to be those systematic variables, and that this is the identification procedure. How do we know if this is a good identification procedure? Or what we're going to see, was the administration of the procedure a blind procedure? Were there pre-identification instructions? What was the construction of the lineup, whether it's a show up, a lineup, a photo array, so on and so forth? What kind of feedback is given? Was it recorded? Are there multiple viewings of these people? Is this a show up? Are there any private actors here and any other identifications that are made, multiple identifications? Now, estimator variables, these go into the reliability of the witness. Was the witness under stress? Was there a weapon? How long was the witness able to view the crime? How far away did they view the crime? What was the lighting of that situation? What characteristics did the witness provide, and what characteristics does the witness have? What about memory decay and whether or not there is race bias in the actual description? There are several issues with eyewitness testimony, and the state here was pretty adverse into making it easier to admit any testimony that may have reliable issues. For this reason, the state wants to utilize the test that I just outlined, the bigger test, the more protective test, to correct the errors and gaps that is kind of left by this Biggers test, the federal test. So, to do that, to fill in those gaps, protect those errors, the test is going to determine whether the identification was made in error of any systematic or procedural influences made by the officers. Was it more than just suggestive, but were there other things that were going on? And 2, whether or not the witness's identification is going to be reliable based off those estimator factors. That's going to be the witness reliability that we had talked about. In this case, in State versus Henderson, if we apply those state factors, the court is sure that the systematic variables would have resulted in suggestive behavior, meaning the courts engaged in poor systematic practices. And because the officers told the witness to make a decision, and so step 1 is out. But if we're looking at step 2, well, the district court didn't review the reliability of the witness because they only did step 1, so they need to go and do step 2. And so this case ended up being remanded for additional information to address those reliability factors. So let's talk about the different lineup procedures. You have your classic lineup, and this is where all suspects are going to be gathered in the same room, and they have a very similar description. Classic lineups aren't used very often anymore because of the cost of gathering everyone together. You have a photo array, which uses a group of photos to match the description, and this is the most common method of identification. It's cheap, it's easy, and it's typically less suggestive. You have a single photo show up, which is when the officers show only one suspect to the witness, asking whether there is an identification of that person. It's not used often because it's typically considered suggestive. You have a non-photo show up, which is when the officers, right after the crime, take the suspect to the witness or the witness to the individual for identification. May or may not be pretty iffy, meaning suggestive. And then you have in-court identifications, which is when you're taking the suspect to the court for identification, and identification occurs the first time in the courthouse. Typically does not happen because this is very highly suggestive. If you're in the courtroom and the prosecutor's on there and say, please point to the person who committed this crime. Well, you've got two options, really. You've got the people sitting behind the prosecution desk, and you have people sitting behind the defendant desk, and the defendant's likely to be the one sitting behind the defendant desk. It's pretty suggestive. Okay, we have three examples of how these principles are done. We have State versus Ramirez first. What happened here is that 3 victims were robbed outside of a Pizza Hut by individuals who were wielding a pipe and a gun. And after the robbery, the victims described their assailants to the officers as young male Mexicans and dressed with blue jeans and blue sweatshirt. Ramirez was an Apache Indian who was identified during a show-up 45 minutes later. And during that show-up, Ramirez was handcuffed to a fence, surrounded by officers, and had spotlights shining all over him as well. No other individuals were shown to the victims of the crime, and the victims only one of those 3 victims identified Ramirez as the actual perpetrator within that show-up. Underneath the federal standard, that rule that we talked about previously, Braithwaite and Biggers, this is going to be very subjective. But if we consider those Neal versus Biggers factors, well, the Utah Supreme Court determines that the evidence was sufficiently reliable to be admitted, even though the evidence is pretty close. Then you have State versus Mason. I don't know how to pronounce it. Again, there were 3 victims that were robbed by 2 assailants, a Samoan and a Filipino. The Samoan was identified as a person who was 5'8", around 180 pounds, and had a short afro hairstyle. That is the person. The defendant here was about 5'9", about 160 pounds, and had a short afro hairstyle. And during the lineup, there were 7 participants, where those without an afro were provided with a wig to have an afro, and those who didn't have mustaches were given fake mustaches to attach to their face. And the lineup here occurred a few weeks after the actual crime had occurred. This is not suggestive, but even if it was, the Neal factors showed that the identification was sufficiently reliable, even though it might seem a bit iffy if people are wearing wigs and fake mustaches. So both this case and the Ramirez case indicate that the reliability factors are going to be pretty police friendly. So we have one more case related here, and that's People versus Kurlskick. Don't know how to pronounce that one either. But what happened here is that there was a bank robbery, and the officers were tipped off about the bank robbery, and the victims were given a photo array nearly 2 weeks after the robbery. In the pictures, the defendant was the only one who was dressed in the clothes that fit the description, And it was also iffy because before as the photo array was going on, the bank called again and said, hey, we think we got the person who actually committed it. And you can see there's this conflicting here. But once again, the court determined that this was not suggestive and that the nil factors were sufficiently reliable. And again, this is going to be admission friendly. What about some other remedies? So now we've talked about exclusion of evidence based on the right to counsel and based on due process. And we've talked about the lack of reliability of eyewitness testimony. What about other remedies to eyewitness testimony? How can you adjust for this if you're still going to allow eyewitness testimony? The first way is going to be through jury instructions. Okay, to illustrate here, Estate versus Allen. Here, Corvax was a white male who was harassed by two young African Americans. Corvax ran to a nearby gas station, called the police, and gave a description of the men's height, weight, race, and clothing. No facial features were mentioned, and then the officers approached two African American males near the scene of the description of the event. One of the men fled, and the other, the defendant in this case, Allen, was taken into custody. And Corvax was asked if Allen was involved in the event, and Corvax responded affirmatively that Allen was the perpetrator, or at least one of the perpetrators. At trial, the defendant asked for a jury instruction about cross-racial identification, meaning that individuals have difficulty identifying specific individuals from another race. At trial, the instruction was denied, and Allen was convicted. So let's talk about this instruction. Well, some states require the instruction. Some states give trial courts discretion in providing the instruction. And then other states deny the instruction altogether because there are other protections during trial. The court in this case adopts this third approach because there are other protections, and those other protections include the cross-examination of witnesses to test their credibility, the questioning of expert witnesses to provide information, and then closing arguments to again discuss reliability. In this case, the concurrence agrees that the instruction was not required, but only because the victim did not make any identification based off of facial features, but instead based it on other features. Had he based it off of facial features, the court says that it should have been required. And then the dissent believes that the instruction should be required. The protections listed by the majority are pretty minimal, especially when you consider the authority and the inability of witnesses to provide accurate information. A judge is also much more authoritative, and the instruction is going to be quite useful when considering how the other protections are going to be unhelpful. Most jurisdictions do follow the same approach and allow the trial judge the discretion to determine whether the jury instruction should be given. This kind of jury instruction about cross-racial identification is called a tell-fair instruction. So that's one alternative. Judges providing a jury instruction about the unreliability of eyewitness identifications. Another alternative is through expert testimony at trial. Our case here is Commonwealth versus Walker. This is another case about a late-night robbery where the victims identified the defendant from a photo array. At trial, the defense filed a motion for limiting to present the testimony of an expert discussing the imperfections of human memory. I think in this case that motion was denied and the expert was excluded. But the majority of 30 states allow this kind of evidence to be admitted according to the discretion of the court. Minority of the states, about 10 of them, don't allow this type of evidence at all. And then we have one last case, rule, which is People in Legrand, which says that an expert may be necessary if the identification is central and is the only piece of evidence involved, which says that it should be required. Okay, a lot of information there, a ton of information. We talked about the risks and the exclusion of mistaken identification, the risks of eyewitness accounts, the inability of eyewitnesses to do it properly, and then the exclusion based on either the right to counsel or based on due process. And then we also talked about some other alternatives to eyewitness identifications to limit and instruct the jury about those limitations, either through jury instructions or through expert testimony. Okay, lots of material there. We have one more case to cover the rest of our criminal procedure material, and then we'll call it good. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.